Very good. So let's start. So this seminar has three themes. One theme is the future of legal thought, the future of legal analysis. Not just theories about law, but the actual way of imagining and elaborating law in context, the practice of legal analysis. And there is now a dominant, a hegemonic approach to the practice of legal analysis in the world. As I suggested in our first meeting last week, it is the purposive, principle-based, and policy-oriented style of legal analysis. It's headquartered in the legal academies of two countries, the United States and Germany, and from there it's propagated throughout the world. It is presented as the wave of the future, as the providential successor to the doctrinal formalism of the 19th century. And of course, it misrepresents its predecessor in the course of being presented in this missionary form. So the first theme of the course is this picture of the wave of the future in legal thought and what we should make of it. I haven't disguised my position. My position is that this is not the wave of the future and that we have reason to repudiate it and to look for another future. So that's the first theme of the discussion. The second theme of the discussion is the relation of this future of legal analysis to the future of society itself, and especially to the future of the dominant institutional and ideological settlement, the established structure, institutional structure or institutional arrangements, and the ideological assumptions with which those arrangements are connected. This dominant style of legal analysis, this rationalizing, policy-oriented and principle-based style of legal analysis is, as we shall see, intimately linked with the last major institutional and ideological refoundation in the world, which commonly goes under the label of social democracy or historically, institutionally conservative social democracy. In its current form, it is a somewhat eviscerated and liberalized form of social democracy, the form that results from its collision with neoliberalism in the late 20th century. And that form that results from the collision of historical social democracy with neoliberalism is what we could call social liberalism. If there is a hegemonic paradigm, an institutional and ideological model that's dominant in the world today, that's it. And the third theme of the seminar is the role of the jurists in relation to the first two themes. What role do they play? What role can they play? What role should they play in the redirection of legal analysis and in the reformation of this established institutional and ideological settlement? Those are the three themes of the seminar. And what I intend for our discussion today, setting, as it were, the context for our subsequent, more open-ended explorations later in the semester, is first once again, to characterize what this dominant practice of legal analysis is. And in general, why it is problematic. What are its costs to society and to the vocation of legal thought? The second step in the argument today is to suggest how this dominant practice of legal analysis appears at different moments in the evolution of this dominant settlement. And I'm going to take that as an instance, an exemplification of a more general problem. How should we think about the structure and about the transformation of the structure? And what role does legal thought and what role do the jurists play at these different moments of structural transformation? In the third step of today's argument, I want to return to the subject matter of the chart that I drew on the board last week, which is how we can understand this dominant practice of legal analysis in relation to the practice that it replaced. And that was this elementary contrast between 20th century legal thought and 19th century legal thought that I began to describe on the board last week. And then in the fourth step of today's argument, I want to deepen the discussion of what makes this practice of legal analysis problematic. Not problematic for society, but problematic on its own terms as a way of organizing the administration of law and the application of law in particular situations. And I'm going to do that by a 5-step argument, which is designed to say how this practice of legal analysis generates certain problems or difficulties that are characteristic of it from within on its own terms. And that then becomes a bridge to a broader consideration of its social consequences. And at each step, and engage, jump in, protest, I'll stop at each stage and invite your interventions. So first, the characterization of this dominant practice of legal analysis. It says that every piece of law should be understood, should be interpreted, should be elaborated, should be applied in the light of the purposes that we attribute to it. But these purposes that guide the elaboration or interpretation of law should be expounded in the language of impersonal policy and principle. So it is a style of legal analysis that is purposive or teleological. It defines law in relation to purpose. It says the interpretation must always be purposive. If the purposes are not made explicit, it must be because they're somehow obvious, self-evident. And then there is implicitly a purpose guiding the interpretation. Second, it is a systematizing interpretation of law. It says that our picture of the law or of extended pieces of it at any given moment is always on the way to forming a coherent view of a certain part of social life. And third, it is an idealizing view of law, because the system that it wants to find in the law, inchoate, evolving toward perfection, is a system that also justifies the law. So, for example, a Marxist interpretation of law as expressing or universalizing the interests of the ruling class would be systematizing, but it would not be idealizing. Now, what are the initial complaints against this way of thinking about law? The first is that it's a mystification of law, that that's not what the law is really like. The law is not this system or any extended part of the law. That if we look at any branch of law, what we are likely to find is that there are certain dominant ideas, but the dominant ideas are surrounded by a penumbra, by a periphery of contradictory material, of contradictory solutions. So instead of a system, what we find in fact in the law is a dialectic between the dominant models and these deviations. So take, for example, property law. The canonical idea of property is the idea that developed in the 19th century, the unified property right, which puts together all the component powers of property and vests them in the same right holder, the owner. The absolute property right, the unified property right. A civilian would say that these major component elements of property are use or possession, usufruct, the claim to the income stream that results from the asset, and alienation, the right to buy and sell. But there are many other more complicated ways of dividing up the component powers of property. In most of the historical moments of most of the great legal traditions of the world, the component properties of the component powers of property have not been connected in that way. They've not been joined and vested in the same right holder. They've been separated. For example, European feudalism was a system for the separation of the component powers of property. The contemporary financial markets, based as they are on trading in derivatives, are based on the disaggregation of the property right. Financial derivatives just are aspects or elements of the property right separated and treated as separate objects for the purpose of trading. So the unified property right, from the standpoint of comparative law and legal history, is not the normal state of affairs in property law. It's an anomaly. But in the current law and the version of law, you could say that it's hegemonic. But it's surrounded by a penumbra, by a periphery of exceptions. Partial, fragmentary, disaggregated, disassembled forms of the property right. At some point, the periphery becomes overwhelming in relation to the core. That is, the ghost at the center is no longer actually describing most of the material, but conceptually, it's still organizing it. And the exceptions, although they may be predominant, are still seen as exceptions. Now take the example of contract law. The hegemonic model is the executory bilateral promise for an instantaneous exchange in the future, which is entirely consummated, exhausted at the moment of performance. But there are many other forms of contract. And the most important exception or anomaly to the bilateral executory promise is the relational contract. The relational contract is an ongoing contract, typically not fully bargained out, not fully articulated, and not for an instantaneous performance in the future, but for a series of exchanges or collaborations. And indeed, you could say that the main object of the relational contract is not this particular performance, but the nurturing or development of the relation itself. And the performances that may happen in the future are just incidents in the development or transformation of that relationship. Now, in any real economy, even today, you could say the majority of contractual transactions don't conform to the perfected model of the bilateral executory promise. For one thing, they are typically contracts of adhesion, in which one party provides the basic terms and the other party simply accepts. And then they may have many elements of what I just described as the relational contract. So that's another example. So why should we take the law of contract to be organized by the bilateral executory promise if the bilateral executory promise is, as it were, just a limiting case rather than the prototypical or dominant form? Or why should we take the law of property to be organized from the perspective of the unified property idea if in practice property is increasingly disassembled or disaggregated and its component powers are vested in different right holders? So the first objection, the first complaint against the purposive, idealizing, and systematizing style of legal analysis, the style that I'm calling rationalizing legal analysis, is that it doesn't do justice to what the law really is. It puts a false veneer, a false cover on it, suppressing or radically understating this element of contradiction, this dialectic between the dominant and the deviant solutions. The second complaint is that it lends itself to being a usurpation of power in favor of the legal notables, the official interpreters of law, judicial or non-judicial, the judges or the jurists placing themselves in the imaginative position of judges. They, the jurists, are invited, or they invite themselves, to put the best face on the law, to interpret it as a flawed, fallible approximation to a system. Not necessarily the whole system, the whole institutional and ideological order, but at least the microsystem, the little system in a particular branch of law. So, and the justification for this idea of putting the best face on the law is that by putting the best face on the law, the legal interpreters, the jurists, could help make law better, especially to the benefit of the groups, the vulnerable or marginalized or subjugated groups, most likely to have lost out in the rough and tumble politics that produced the law in the first place. So under the cover of this idealization, the complaint would be, what's really going on is an appropriation of the power of democratic lawmaking by the jurists, a usurpation of the power of the people. The third complaint is perhaps the most fundamental complaint, and that has to do with your vision of the vocation of law, the vocation of legal thought. What is it for? Is it for the judges? Is it for adjudication? Should the jurist imagine himself as whispering into the ears of the judge? Should his horizon, his epistemic horizon, be the horizon of the official adjudicator, trying to provide the best solution to the particular case? So Hegel and all the German historicists said, law is the institutional form of the life of a people. Developed or defined in relation to the understandings of interests and of ideals that are supposed to make sense of it. Our ideals and interests are always nailed to the cross of the institutions that represent them in fact. So a large part of what our ideals and interests mean results from their practical institutional representation. In this sense, you could say that our ideals and interests are always crucified on the rules, on the institutions, and on the practices. And the law is just the site of this crucifixion. So how then do we develop or reform the institutions or the practices and revise our understanding of our ideals and interests? By some dialectic. That is, we change the rules, the institutions, the practices to realize our ideals and interests as we now understand them more fully. And then the tinkering with the institutions and the practices in turn allows us to discover ambiguities in our ideals or in our interests which were hidden to us until we undertook those revisions. So the most important thing about law and legal thought is to participate in that dialectic, or better, to be that dialectic. And this other task of assisting the judge, of whispering into the ears of the judge, is a secondary vocation. Now, of course, it's the vocation in which the legal professionals may be especially interested, but so what? They don't represent the universal interest, the interest of society. And then the problem of course, is that no one represents the interests of society. The place is vacant of the the party who might be interested in the promotion of this dialectic. So what the rationalizing legal analysis is doing, according to that complaint, the third and most fundamental complaint, it is that it is implicitly subordinating the most important task of legal thought to a secondary task. And at the same time, it is mystifying law in the process of subordinating the important vocation to the lesser vocation. And it is creating this additional power for the legal notables to change the law in the process of representing it. Now, let me make one further comment before I ask for your observations. The point about usurpation or idealization, how should you understand it? Let me suggest an analogy to you, which is of special significance in the American context. The interpretation of the Constitution. So you know that in the United States, there is a cult of the Constitution. So most countries in the world have had many constitutions, and they change their constitutions from time to time. But in the United States, the Constitution is regarded as a sacrosanct document to be changed only in extreme circumstances. The official amendment process is very stringent, and it's very hard to comply with its requirements. So in the United States, the basic way of changing the Constitution is not to change it, but to reinterpret it, to pretend that it means something different from what it used to mean. That's the basic form of constitutional revision in the United States. But the Americans don't appreciate, on the whole, one of the implications of this preference for change through reinterpretation rather than change through overt amendment, which is that it has built into it a bias against structural change for the following reason. If the Constitution says that there should be 3 branches of government, it's very hard to pretend that what it really means is that there should be 5 branches of government. In other words, the structural layout of democratic politics is very hard to change by reinterpretation. But it is relatively easy by different rhetorical devices that the jurists dominate to reinterpret the provisions of rights, like the Equal Protection Clause or the Due Process Clause under the 14th Amendment. And therefore, this approach that inhibits overt revision but facilitates reinterpretation has a built-in bias against structural change in the structure of the government, and in favor of the reinterpretation of rights. Now, imagine that expanded to the whole of law, because that, in a sense, is what this rationalizing legal analysis does. It says, we will change things by reinterpreting the rights. We will not change things by reorganizing the structure. And that's then what may increase the significance or the severity of the problem of usurpation of power. Now let me stop there and ask for your comments. So this is just the initial step now of characterizing this dominant style of legal analysis and beginning to understand its consequences. Yes.
I have a question about what you said in the end about reinterpreting the rights for changing legal analysis. What would be the direct analogy between
What would be?
the direct analogy between, say, amending the constitution and as a
What would be what?
the analogy?
The analogy? Well, so the analogy is saying the bias away from structural change and toward reinterpretation of rights is one of the natural consequences of this cult of the Constitution. If you say, we're very reluctant to change it, we prefer to change it by reinterpreting it, so it results in that. That's what happens in rationalizing legal analysis with respect to the whole of law. That's the analogy. So it says, we're not politicians, we don't have a structural idea, we're not proposing to reorganize society and its institutions. But we create these improving, idealizing interpretations of law. So what I'm saying is that what results in the constitutional culture of the United States with respect to the attitude to the amendment process and its consequences is what rationalizing legal analysis does for the whole of law. And one of the reasons why the project of rationalizing legal analysis may seem more plausible in the United States or attractive is that it agrees with this constitutional prejudice. In a way, it could be seen as a generalization to the whole of law or an importation to the whole of law of attitudes and methods already nurtured in the approach to the Constitution. But of course, that's not really an adequate explanation because rationalizing legal analysis is defended by the jurists all over the world. And in most of the world, constitutions are changed overtly with great facility. So it's just an explanation of how you could see this parallelism in the United States between the attitude to the Constitution and the attitude to all of law. I think that in this matter, for a jurist, one of the most troubling things, and will be a source of perplexity for us as we go along, is this question of the agency. So I say there are two vocations of legal thought. One vocation is to be this normative doctrine, this way of discussing the whole and its transformation part by part. The structure, which are the institutional arrangements and the ideological assumptions associated with them, the structure of the market order, the structure of the democracy of democratic politics, the structure of independent civil society outside the market and outside the state. The larger vocation is to deal with that and to imagine it not in the way that classical European social theory did, as a choice among systems like capitalism and socialism, but to imagine it at the level of detail, at the micro level, where real structural change takes place. Because the overwhelming majority of real structural change in history is fragmentary. And where do we find the evidence or the materials for this fragmentary structural change? In principle, we find it in the law. Because the law is where the structure is represented in full institutional detail and in relation to the ideological assumptions that are supposed to make sense of it. So the specialists in this microstructural change should be the specialists in law. But then we're surprised. We're not surprised because we know what the situation is. But an outsider might be surprised to find that that's not what the jurists do. What the jurists do is that they're technical assistants to the judges or quasi-judges. Their typical imaginative attitude, their perspective, is to imagine themselves in the situation of judges. And that's a lesser vocation. That is a responsibility of law or of legal thought. But it's like a little thing compared to the big thing. But the little thing takes over for the jurist, and the big thing doesn't exist. Yes?
Just thinking about that primary vocation of law, jurist, as you described it.
Yes.
Where and how do you envision that taking place? Does that take place in a courtroom before a judge?
No, it
is by
doesn't.
academics?
No, it doesn't take place. It doesn't take place. If you open a law review, the American Law Reviews, you find that the articles are not about that. They're about what the courts are doing, what the Supreme Court did, how cases should be decided. They're not about this micro experimentation. It's just not the topic. So they might say, well, that's for someone else. Philosophers, political scientists, or someone. But then go over to the political scientists, and you see they don't do that either. So the thing that's most important is not done, right? Because after all, here we have the perspective of doctrine, as I mentioned, the doctrinal disciplines. They have this different methods. So the doctrine, remember, I claimed last week, the doctrine is continuous with the subject matter. It's constitutive of the subject matter. Theology is constitutive of a religious faith. It's not just about it, as if it were looking at the atomic structure of a physical object. It sees the subject matter as having this symbolic complexity. The surface has to be understood in relation to something underlying it, which are, in this case, the interests or purposes or ideals. And it matters. It has authoritative force. It puts at stake the power of the state, the power of politics. But the focus in legal thought, although potentially deep, is also very narrow. It's about this problem of the professional application of law. So that this larger vocation that you were just asking about appears to be bereft of an agent. Who is to do it? So what I'm saying is, the question that you just asked doesn't have a satisfactory answer in the situation that we find. But your whole attitude to the lesser task would be quite different if you saw it as subordinate to the higher task. So, for example, one kind of obvious response that you could have to that list of 3 complaints that I adduced against rationalizing legal analysis is say, the interpretation of law should be purposive, if not explicitly purposive or teleological, then implicitly purposive, but it shouldn't be idealizing or systematizing. We shouldn't mystify the law to pretend that it's on the way to being a system, and we shouldn't pretend that it's the best system. So we should affirm its purposive character, but deny the other features of this practice. That's one thing we could do with it. But then we would have a deflated, realistic practice of legal analysis, which would leave the jurists without this high-flown job of theirs, right? And then there'd be more space, more practical and imaginative space to address the other task, the other job, the higher vocation. And of course, then there's the whole practical problem of how would this connection of the jurist to the people be developed? Is it through the political parties? Is it through some other means, social organizations, social movements? None of those questions are answered. So the question of agency is left unanswered, but it is a fundamental question of legal thought if you have this broad idea of what law is about. Now, I just remember that little disquisition last week about the candidates for inclusion in the national elites and what they go to law school for. I said, they go to law school to learn what the deal is in their society and what is the official discourse in which to debate the deal, to elaborate it. Well, that's related to this idea of the higher vocation. So actually, the practical people in the world, the candidates for these positions as politicians, diplomats, bureaucrats, entrepreneurs, whatever, they also expected to find that in law school before they discovered that it's really just about a taxonomy of doctrinal categories and about the judicial setting. So they should also be surprised. In any event, this is just the background to a very long argument. Yes?
I wonder to what extent you see that this argument or this way of looking at things could be expanded to the international or international law. Does it apply, like, can it be schemed up to international law unproblematically, or do you see that there's a difference between national law and international law that perhaps might be an obstacle to translating that kind of democratic experimentalism to the global?
Well, I don't think there's an insuperable obstacle, but some people do, because if you start out with an Austinian view of law, the law's command or rule, there's an obvious problem in international law, that there's no world government, there's no super sovereign, there's no world empire or world state, and therefore no one can be in the position of giving the final order. But I don't see that as an insuperable obstacle. That's an invitation to formulate law in a different way, from the bottom up, in which you could say in international law, the fundamental thing is the cooperative activity of the sovereign states. The sovereign states are armed, they threaten one another, so the most obvious cost of the division of humanity into these sovereign and armed states is war. And but those of us who are the majority of humanity, who don't want a world state, think that we have to pay that price to avoid something worse, a world empire. We don't want the super sovereign. And then how does law arise? So the cooperative activity of states produces over time what you could call proto-law, because the agreements, the treaties, the collaborations of the states then form this material, which is like an antecedent state of law. And this, after all, is not radically different from the way customary law evolves in pre-state societies. So that's the fundamental character of international law. And the hope is that this cooperative activity could become the ascendant element in the creation of law over time, of world law, international law.
But from what I understand, another obstacle, I mean, yes, the lack of a sovereign is one obstacle, but another obstacle that people have observed that international law tends to be even much more dominated by experts and expertise. And perhaps one explanation for this is the lack of things like a world parliament or constitutionalization, which kind of makes international law much more vulnerable to rationalizing tendencies that perhaps makes it much more elitist or alienated from the interests of social movements or social groups or whatever.
That's interesting. That hadn't occurred to me as a way of, as a problem with international law. So you associate its radical decentralization with technicism, with a greater role of the technical experts?
It is criticized for being over.
I mean, you could say you could say that if, in the sense that a common law, like the common law, the jus civile common law, arises because there's no code, there's no codification, there's no single sovereign, right? So then the jurists are seeking to shape this inchoate material. But is that a problem? What are you saying? That the international legal elite is pretending?
Because there's no clear constituency to the international legal elite. So it tends to be much more, and this is an argument, perhaps like we can debate it, but there's a kind of like a sociological argument to the effect that the professionalization of the international legal elite makes them lack a constituency. There's no one that they can be held accountable to,
Yeah, but
and therefore it makes it much more technocratic.
But that must depend on ideological movements. So it would be plausible to think that a disproportionate part of the theoreticians and practitioners of international law are globalists or closet globalists, that they in fact believe in the supersession of the national state. They believe, for example, in world federalism. And the vast majority of humanity doesn't want world federalism and doesn't want a world state. Me included, by the way, so I don't want it either.
And you equate the two, world federalism with a world state, like you see those
Yes, of course, because federalism, a federal system is the system of a state. So I think it is on the way to being a state. And humanity doesn't want that. So the premise is that humanity develops its powers and possibilities by developing them in different directions. If we're going to have a world state, we're going to have a cadre of jurists and bureaucrats and emperors who will be this world state and will put the world on a channel. Look at the European Union. It's like a little model of a world state. And we could look at it and say, we don't want that. We don't want that for the whole of humanity. But that would be the beginning, of course, of a long debate. Because after all, the European Union has often been represented as a model for globalization. Yes. You.
Yeah, so in my country, Slovenia, judges are still seen as bureaucrats, not as a third branch. So usually law review articles are addressed to the legislator. So they would rationalize and say, the law says this, there's one solution and we think it's wrong. You should change the law to make it a bit better.
Yes.
But the arguments always come from within law. And if you want to change the labor market as such, the law professor will say, well, this is not up to me, this is up to the politicians to do. So we still have this separation between legislative politics and some doctrinal advice to the legislator. So
Yes.
I think you want to transcend this law and politics divide. Do we just need politicians who understand the law? Or do we need some hybrid? Otherwise, I just think we need to educate politicians about the law, and is that it? Or I don't understand how this system is different than what we have now, where lawyers can just advise politicians how to achieve.
But what is the particular question that you're asking then? What is the particular point? Because the question always is, what are the accessible transformations? What are the possible next steps? And where do we find the material for the design of those next steps? And that's a question that, so you have to, a typical way in which structural change takes place is there's a set of variations, there are deviant solutions in the present order, and you say, some of those deviant solutions can be starting points for an alternative that we want now. Now, I'm not discussing the label of who does that. You could call it a politician or a jurist or whatever, but it does depend on the mobilization of some of these technical details to create an alternative general solution.
Yeah, for example, in my country, the left always has great ideas, but then they don't have any lawyers in the party, and then they find out about the existing
Yes.
law, and then they're like, oh, I guess we cannot do it because we have these international treaties.
Yes.
So I'm just wondering, yeah, what could lawyers do here?
What should what?
So do we need lawyers who, I don't know, do we need lawyers?
Well,
who-
forget about the label lawyers, because I think the question is, how do we, where do we get, and how do we get, and how do we think about these institutional details that are the real material for structural alternatives? Someone has to do that. I don't care what you're going to call them, whether you're going to bring them under the label of lawyers or not, but the question is, where do you find it, and how do you find it, and what is the method by which you take a localized deviation and imagine it generalized as the alternative? I mean, take, for example, the question of unionization, which I was discussing the other day in another course. There are two models of unionization in the world. There is the contractualist collective bargaining model, which prevails amply in the rich North Atlantic democracies. So it's imagined by analogy to contract. Say, in the employment relation, there is radical inequality of bargaining power, and therefore let's redress that inequality and reestablish the reality of contract by collective bargaining. So the workers will be collectively organized, they'll be able to stand up to the boss, to the employer, and contract will no longer be just a facade, we'll give it reality through collective bargaining. And the collective bargaining system then has two principles. One principle is unionization is voluntary because it's an analogy to private contract. And the union is completely independent from the state. Now, that's not the only system of unionization that exists in the world. So there's at least one other system. There is a system that prevails in most of the Latin American republics, both in Central and South America, which is the corporatist labor law regime. Its original inspiration was fascist Italy, Mussolini. But its application in Latin America was by the left, by the leftist nationalist populist regimes. Perón in Argentina, Vargas in Brazil, Cárdenas in Mexico, and so forth. And the corporatist regime says everyone should be unionized automatically. Unionization is not something you have to fight for, it's a gift of the law. And the unions are under the guidance or the tutelage of the state through the Ministry of Labor. So it's a form of what a political scientist would call controlled popular mobilization. Now, the collective bargaining system has many defects. Now, a tiny part of the population is unionized. And most of, like in the United States, and most of those who are unionized are in fact employees of the state or of the third sector of charities like the university, not workers. That's a tiny fraction of the labor force. So it hasn't worked, it's failed. The tendency of a contractualist system is to express and reinforce the underlying inequalities of the production system. So if you have a highly hierarchical production system, in the capital-intensive firms, the workers will share interests with the owners. And they'll be able to make deals. The wage bill is a small part of the cost of production, and it will be the interest of the workers and of the workers to have a deal, to the detriment of all the other workers in the less capital-intensive parts of the production system. Second, the contractualist regime focuses all the effort on unionization. And the battle of unionization has to be refought every day. The union has to be able to deliver in order to maintain its existence, or it won't go on, it won't survive. And third, the tendency of a contractualist system is to put all the focus on the economistic demands, wages and benefits, rather than on broad structural concerns. So these are the obvious defects of the contractual system. So, but on the other hand, the corporatist system subordinates the unions to the state. So what would be a solution? A solution would be, for example, a hybrid regime. It would take from the corporatist system the principle of automatic unionization of all the workers. Everyone automatically belongs to a union, and then you design the union system according to the sectors of production and territorially. So the combination of sectoral and territorial criteria then results in the shaping of the whole union system. And the workers have movements, there are different union movements, affiliated or not with political parties, and they compete for position in this unitary structure, just as political parties compete for position in the democratic state. So what might you want? You might want a hybrid regime, which says, we'll take from the corporatist regime the principle of automatic and universal unionization. But we'll take from the contractualist regime the principle of complete independence of the unions from the state. That's an example of structural change with momentous consequences. I think it's probably not feasible now because it's too late, simply because the ship has sailed already. Unionization may be irrevocably prejudiced as a response to the problems of economic inequality. But that would be an example of something. Now, who is to do that? So forget about the labels, as I said. It doesn't matter if we call them politicians or jurists, but someone has to know that these two regimes exist. And someone has to figure out the economic and political consequences of this division. And someone has to invent the hybrid regime. Now, who's going to do that in this world in which humanity is divided into these sovereign states? Yes.
Yeah, you mentioned that genuine structural change is always fragmentary, and jurists have a handle on the detail, which is why they should be looking at that.
The comparative advantage of law is that it deals with the details.
Yes, and I understand that premise, but I'm just wondering, aren't there also many examples of structural change which are not fragmentary? Like if there's like a violent revolution, for example, and other like non-fragmentary structural changes.
I think that the idea of total change, revolution. So first of all, the common idea of revolution confuses two elements, which are the idea of total change, you change everything, and the idea of violent change, which is also associated with revolution, because the canonical idea of revolution is not that there's non-violent total change. How would it happen, right? So Hegel has an argument in the Phenomenology of Mind that this violent change is a kind of rage of impotence. Why do you have violence? Trying to force the hand of reality. This idea of revolutionary change is, I think, largely a fiction. If total change doesn't exist. So Tocqueville wrote a book about this, on the Ancien Regime. And the central theme of his book was that France after the revolution was very similar to France before the revolution. So total change is an idealized limiting case. It's not the description of a real state of affairs. The real change that can become increasingly more inclusive is the one that results from the cumulative practice of fragmentary change. That is, if you try to change everything at once, it's a fantasy. And because it's a fantasy, it has to be imposed by violence. Hegel's point. Huh? So if you really want to change everything, you'll change everything step by step and piece by piece, because that's the only way in which you can change everything.
So then, are you suggesting that lawyers or whatever they label as people with a handle on the institutional detail should be leading the change, and that's the only way in which real change can happen? Because otherwise, if there's, for example, violence, like it's a myth and it doesn't actually change things. Like, is that the argument? That people with knowledge of details, they should be leading the change or framing the debate or informing people?
No, but there's a step there. Whoever desires change in the world must have radical intentions and a prophetic vision, but must at the same time have his hand on the details, which allow him to do this stepwise. Now, I'm not disguising the difficulty of that order, right? I said, this is a very tall order. Who are these people? Going back to the comment in the first meeting, prophets and technicians at the same time? Does that exist? So I'm not saying that the content of this agent can be easily supplied. It can't be. And that helps to explain why the world is not, in fact, changed in this way. But we shouldn't confuse that with these categories like the lawyers. Because if you ask, what are the lawyers like? Look around you to see what they're like. Are those the people who are going to change everything?
Just one final question. Like, are there historic examples of the kind of change that you are talking about?
I don't understand that, because that's the only kind of change that does exist in the world. That's what I'm saying. You say, give me historical examples of fragmentary change. Those are the only examples that there are. There are no other examples. Where is there an example of this totalistic change? That's what doesn't exist. What exists is this piecemeal change. All the stuff of reconstruction in history is this fragmentary change. So if you ask me what's an example, I say everything is an example. All right, so should we go on to the next stage, or does someone have a further? Yes.
Sorry, I have another question. Just to clarify, so I'm not familiar with Tocqueville's account of France before and after the revolution. I'm wondering, one of the accounts I'm somewhat familiar with is Hannah Arendt's argument that revolution was the moment in which the relationship of the people of France to the future, for the first time, went forward. It was basically kind of an ontological change at the level of the broader society.
Yes.
I'm curious as a clarifying question to your point about ontological changes as being an example of the sort of total changes that you say don't exist. And that's my actual question, which is those changes that are produced by jurists that change what we both aspire to be, but also how we identify with ourselves.
Yeah, because the fragmentary change is not just change of institutions.
Sure.
It's also change of consciousness, right? And consciousness changes in the same way, right? So one of the ways in which we change consciousness is by changing its practical basis in the institutional organization of society. So, for example, people say, well, the Americans are inherently less politicized than some other country. But I say, give me a rule of mandatory voting in the United States, as exists in many democracies, rich and poor in the world. Give me a rule, a system under which television time cannot be bought, but is distributed for free to the political parties and social movements as a condition, as one of the conditions under which the media companies hold their irrevocable licenses and do their business. And I will show you that these changes will change that political culture. So the things that are supposed to be inherent in national culture or identity are much more likely to be the effect of a series of cumulative changes in the institutional arrangements. Otherwise, we couldn't change ourselves, and societies couldn't change, because they would always be in the stranglehold of their culture, of their form of consciousness. All right, so let's go back. Imagine that chart that I drew on the board last week that describes the relation of rationalizing legal analysis and its theories to what came before, to the supposed doctrinal formalism of the 19th century. So, remember, the first column in the chart was the conception of law. So the idea was, the 19th conception of law was, and here we already have a problem, because according to the official account now of the contemporary jurists of what 19th century doctrinalism was like, the account is it was the idea that law is a system, a gapless system of rules from which you can infer by a quasi-deductive method of inference the single right solution to every legal controversy. That's what they claim. But I want to say that's not what 19th century legal thought was. 19th century legal thought was a typological construction. It said there are different types of social organization. One of those types is the free society, the scheme of order liberty. And in those types, the content is predetermined and revealed by progressive concretization, determination, and that's the method. Now, then the 20th century idea of law is, no, it's a bundle, it's an open system of rules, standards, principles, and policies. It's not this gapless system of rules from which you infer the single right solution. But in fact, this idea is to say that the mixed economy, liberalized social democracy, the now hegemonic institutional and ideological settlement is a kind of order or regime. And rationalizing legal analysis makes sense in relation to it. So it's not so much the opposite of the 19th century idea as it is a weaker or more generalized form of it, of the same proposition. The 19th century form says, there's a type, this is the content of the type, law is the theory of that type, the content of that type. That's the same as Marx's idea. The Marxist idea is very close to the central idea of 19th century legal science. So is this 20th century idea the opposite of that? Or is it just like a weaker form of that? Now then the second column there was about the method or practice of legal analysis. So in the 19th century, it was on this account, on the 20th century account of the 19th century, it was all deductive. It was this mechanical categorization and conceptualism. I say it was not that. It was the concretization of the type at successive levels of concreteness. The third column asks, what was the mission? What was the view of each of these practices of legal analysis of its mission? The 19th century view was, here's the system of private rights, the liberal system of rights. Adhere to that system and you will be both free and rich. The idea is there's a pre-established harmony between the institutional and legal conditions for economic progress and for individual emancipation. The same institutional arrangements that are the basis for wealth, national wealth, are also the basis for individual freedom. Now, what's the 20th century idea? The 20th century idea is that the rights promised by the law, the rights of individual self-determination under contract, and collective self-determination under democracy, depend on practical conditions which may fail. Defeasible conditions. So the project then is to reorganize all of law as an interplay or dialectic between the parts of law that define the rules of self-determination individual or collective, and the rules that guarantee the conditions for the practical exercise of those rights. So Anatole France said, the law allows both the rich and the poor to sleep under the bridge. There's the right, but there isn't the practical condition for the exercise of the right. So what does 20th century law do? It says the fulfillment of the right is not a guaranteed promise. So we have to reorganize it so we will create the practical conditions for the enjoyment of the right. So, for example, that's what, within a particular branch of law, like contract law, the rules about unconscionability do with the rules about contract formation. They say, you have freedom of contract or freedom to contract, so long as the contract is not unconscionable. That's what labor law does in relation to contract law as a whole. In the employment relation, there's radical inequality of bargaining power. So then the contract threatens to become just a facade behind which there's the reality of oppression rather than the reality of contract. So in order to reestablish the reality of contract, in the conditions of the radical inequality of bargaining power in the employment relation, we have to have countervailing power, collective bargaining, unionization. And unionization will reestablish the reality of contract. And that's, in a sense, what all of public law does in relation to private law. As private law organizes a market, the market order. Public law creates the conditions under which the market order is no longer just a sham, but is the real basis for self-determination. Now, there's a mystery, right? Because there are always different ways of picturing the conditions for guaranteeing the practical enjoyment of the rights. There's not just one way. As in the discussion we just had about unionization. Should we have collective bargaining? Should we have the Latin American corporatist regime? Or should we have the hybrid regime that I described? And if there are different ways of defining the method or the means for the practical enjoyment of the rights, the next step is then to say that there are different possible futures for that system, right? The hybrid regime could be a little detail that together with 100 other details would be the beginning of a different future for society. It's crucial to understand that 20th century legal theory or contemporary legal thought doesn't take that step. It stops short of that step. That is, it stops short of the step of developing the debate about the different ways of defining the conditions for the practical enjoyment of the rights into the different ways of organizing the institutional order as a whole. The idea of alternative futures is not inferred from the debate about the practical enjoyment of the rights. But why not? There's no intellectual justification for stopping at that point. Now, the fourth column was about a crucial distinction in these two moments of legal thought between good law and bad law. So in the 19th century, good law is the distributively neutral law of coordination, like the market order, the rules of contract and property. Bad law is the law that happens when a faction or a class in society wins the power of the state and distributes benefits to itself under the disguise of the law. Bad law is politicized and redistributive. Good law is unpolitical and distributively neutral. So in the United States, that 19th century distinction was associated with what is called Lochnerism. So it was the principle in conservative 19th century American jurisprudence that a particular set of arrangements was entrenched in the Constitution to guarantee a particular kind of market. So, for example, the prohibition of minimum wage legislation or of progressive taxation. So the Americans came to think that this distinction between distributively neutral law and redistributive law, which was the linchpin of 19th century legal thinking, cannot be defended, cannot be sustained. And it has to be replaced by a new distinction, which was there in the fourth column of that chart, between law as deals and law as impersonal policies and principles. That's the new distinction. But notice that the new distinction has a family resemblance to the earlier distinction. It's like a weaker version of the same basic kind of idea. So, what does this mean, this distinction between law as impersonal policy and principle and law as deals? It means the following, that you could picture the law as simply the result of some conflict of interest at the moment of lawmaking, of legislation. So, for example, there's a conflict between the interests of the importers and the exporters. And the trade law that results is a snapshot, a picture of the correlation of forces at that particular moment. So the law is just a deal. It's an arbitrary truce line in this conflict. So that's what's supposed to be bad. Law as deals is bad. Law as impersonal policy and principle is good. So the distinction between distributively neutral law and redistributive law was supposed to be unsustainable, and it's now going to be replaced by another distinction between law as impersonal policy and principle and law as deals. But law as deals is probably going to occur anyway. So, for example, in the late 19th century, in the late 20th century in the United States, there was a faction of the right-wing law and economics movement which said, some of law is deals. And that's bad law. And instead of pretending that it's never like that, we should recognize that it sometimes is like that. And we should adopt a series of antidotes to contain it as a kind of cancerous cyst. So, for example, the rules governing statutory construction, the principles of statutory construction would say, to the extent that law is impersonal, it can serve as the basis for extensive interpretations, extensive analogical interpretation. We can take every part of law and say, we can use it as a basis to extend the analogies to some other part of law. They say, if it's bad law, if it's law as deals, confine it. So then the interpretation shouldn't be extensive, it should be restrictive. That was the practical implication of the distinction. It's problematic, this distinction. It's problematic in itself and it's problematic in its consequences. Now, the idea of the 19th century idea that there's a distinction between politicized redistributive law and law that is distributively neutral has not vanished completely. It survives in a series of vestiges or ghosts. Let me give you an example. In American constitutional law, there is the doctrine of state action. So for the purposes of applying certain constitutional principles, like the principles of equal protection or due process, you're supposed to be able to distinguish between situations in which the state is complicit. The state is complicit with the creation of those situations and situations which are somehow supposed to be pre-political or just naturally there. Now, is that true? Can you distinguish between situations which are natural and situations which are politically shaped? A social theorist might say, no, you can't. The state is always complicitous with every situation, and therefore the doctrine of state action makes no sense. The doctrine of state action is an afterglow, a ghost-like apparition that still contains within it some of the earlier distinction between distributively neutral law and redistributive politicized law. Do you see that? Now, in the last column, the question is, what is the method for then preserving this good law against the bad law? For the 19th century, it's either this mechanistic, quasi-deductive inference from the rules, or it is the typological concretization. For the 20th century, it's reasoned elaboration, reasoned purposive elaboration of law, in which the purposes guiding interpretation are defined in the language of impersonal policy and principle. And if that fails, then the backup is constitutional invalidation. In the 20th century, it's the same thing. So now it's that. So in the 19th century, it was that. In the 20th century, it's reasoned purposive elaboration in the language of impersonal policy and principle. Now, if you add all this up, what's the implication of this comparison which I do? It's the following. The basic approach of rationalizing legal analysis and its theories is 19th century legal thought was the Dark Ages. It was a series of superstitions. One of the superstitions being conceptualization, deductivism, and so forth. What the chart is suggesting is that 20th century legal thought is basically a continuation of 19th century legal thought. It's weakening. And so 19th century legal thought makes a set of heroic claims, like the claim that there are types of social and economic order, that each has a built-in content, or the claim that you can distinguish between distributively neutral law and redistributive politicized law. 20th century legal thought makes similar claims, but only weaker. But weaker, as it were, of the same sort or in the same direction. So the best way so the self-understanding of 20th century legal thought is that it's in some sense the opposite of 19th century legal thought. 19th century legal thought was under the cloud of all these superstitions, it was shackled. The alternative view that I'm suggesting is that 20th century legal thought is the continuation of 19th century legal thought on the basis of a retreat to a more defensible position, to a weaker position. Now, does that make sense? Do you agree with that? What, you have a comment about that? Let me make one more move here, which is the relation of this practice of legal analysis to structural change and to different ideas about structure. So the structure is the basic set of institutional arrangements and ideological assumptions related to them that shapes the surface routines and conflicts of society. So the structure is, in a sense, the fate of the society. And in particular, the structure shapes the conflicts and routines that are about the way in which we collectively create the future within the present, using the crucial resources of economic capital, political power, and cultural authority. The preservation or reformation of the structure is the supreme object of ambition in practical politics. And of course, that's the distinction between who's serious and who's not serious in politics. Whether the activity is about the structure, about its preservation or reformation or not. And the explanation of the structure and of structural change is the supreme object of ambition in social and political theory, of explanatory ambition. And we have a problem because there is no adequate view of structure in contemporary thought. Classical social theory, like Marxism, had a view of structure, but we can't believe in it anymore. So it imagined that these structures of social life are invented, they're created, we created them, and because we created them, we can understand them. But the Marxist view of structure was surrounded by a series of determinisms in which we can no longer believe. So first it said, there's a short menu, there's a closed list of possible structures. They're what Marx described as the modes of production: slave society, feudalism, capitalism, socialism. The second assumption was the indivisibility idea. The structures are indivisible. They change all of us all at once or not at all. And this has momentous implications for practical politics, which is that we then have a binary idea of politics. All of politics is either the reformist management of a structure or the revolutionary substitution of one structure by another. And the third idea is that there are laws governing the foreordained succession of these structures in history. If there are laws, we don't have to have a project. And in fact, we can't have a project, or we shouldn't have a project, because history has a project for us. So contemporary social science, on the whole, has no vision of structure. Its central theme is normalization or rationalization of structures. Has no structural ambition, no theory of structure. It rejects these illusions of false necessity, but only because it suppresses structural vision altogether. So we, therefore, are left without any usable idea of structure, of how to understand it, and of how to talk about its transformations. Now, how should we, in the broadest sense, imagine structure? So let me go back to the suggestion in our first meeting. So, these structures, these institutional forms, are the result of ongoing practical and visionary strife in history. The strife is periodically contained or interrupted. It's like the game of musical chairs. The music is the strife. When the music stops, we sit down on the chairs. The chairs are the structures. But the strife is never completely interrupted or never perpetually interrupted. It's just temporarily interrupted and relatively contained. And the result are these structures. So now imagine 3 moments of structure. Now, I'm not saying that this is perpetual. I'm not claiming that this is eternal law of our experience. Because after all, we might have an interest in getting out of this situation in which there are brief interludes of structural change, like you were saying, revolution, and then these long periods in which basically nothing happens. And our interest might be to get out of that, so that structural change would go on all the time in some lesser form. And we wouldn't have this choice between stasis and chaos. So let's imagine then that there are 3 moments, and let's picture the situation of legal thought in each of those 3 moments. So there's the first moment that goes refoundation. The structure of the ideological assumptions are changed. In American history, those 3 moments have a name. They were the foundation of the Republic, independence, the War of Independence, and the constitutional foundation. That was the first moment. The second moment is the Civil War and Reconstruction. And the third moment was the New Deal. The Depression, World War crisis, and the New Deal. At the moment of refoundation, the jurists appear at the center. They participate in the refoundation, like Roosevelt's Brain Trust, or the founders, the authors of the American Constitution. They're there at the table at the moment of creation. Then comes a second moment, the moment of normalization. The revolutionary project is then generalized and normalized in law. And that corresponds to, in the United States, say the period from the end of the Second World War to the 1980s. So the idea was, the legal idea has to be then transformed into a whole doctrinal project. And the jurists appear then as the systematizers or normalizers. What was the specifically legal content of this project when it's normalized? One of its aspects was that a new body of public law, the law of the redistributive and regulatory state, including the law of the administrative agencies, was superimposed on a largely untransformed body of private law. Private law was left largely intact. The rules of the organization of the market order, the law of property and contract. And on this untransformed body of private law, there was superimposed a new body of public law. And the theory of that, the working out of that in legal detail, was a large part of this project of normalization. And now comes a third moment that goes from the 1980s to today, and that's the moment of darkening. So what are the characteristics of the moment of darkening? The refoundation becomes more and more distant. It recedes into the past. Its lessons for the fighting issues of today become ambiguous. What does it say, for example, about plant closings or offshoring, or about NAFTA, or about affirmative action? It's an oracle that no longer delivers a clear message as it recedes into the past. The second characteristic of the legal culture in this moment of darkening is that the attitude to its characteristic product, which is the law review article, becomes ironic and tactical. So the conventional law review article in the age of rationalizing legal analysis has a formula. The formula is to say, here's a part of law, which at first seems to be a jumble, it's very confused, it's contradictory. I will show you how we can think about it in the light of a scheme of underlying policy and principle that will make sense of it. But not of all of it, but of most of it. And then there will be a part that I'll argue we should reject as mistaken in the light of this scheme of policy and principle that I've expounded. So you have to say that implicit in the law is a scheme of policy and principle. It's just there, it's latent in the law. And it explains most of the stuff, but it doesn't explain all of it. By some fortunate accident, by some happy balance. Now, what's characteristic of this moment in legal culture, which I'm calling the moment of darkening? The people who write these articles very clearly no longer believe in them. They don't believe in this story. So the law review article continues to be designed according to this formula. But the formula is meant tactically to achieve some objective that the author of the article considers to be good for some independent reason. So, in other words, there's an underlying political program which is not revealed in the article. And the apparatus, this whole rigmarole of saying there are these underlying policies and principles, they explain most of the stuff, they don't explain all of it, they lead to the rejection of, this is all just tactics, delivered from an ironic distance and a perspective of half-belief. Now, there's a third characteristic of legal culture in the moment of darkening, which is that the role of the refoundation, remember I said, the refoundation recedes into the past, and its message for the fighting issues of today becomes uncertain. The role is taken by theories. So, the rights theories, the law and economics theories, the legal process theories that say that each agent in the legal system has distinct responsibilities which should be carried out by distinct methods. So it's as if theory, these theories in particular in the United States, stand in the place of the refoundation. The refoundation speaks less clearly, but the voice of the refoundation is replaced or amplified by the voice of the theory. Like at the end of Don Giovanni, the dead commander comes onto the scene in the form of a statue. And this statue is the theories. He speaks. And it's very strange because each of these theories makes the claim that its narrative is implicit in the law, that it's latent there, or at least partly latent. But they're completely different theories. So they have narratives. They say this narrative is implicit in the law, but they're completely different narratives. The plurality of the narratives casts a shadow of suspicion on the credibility of this idea that they're latent there. How can they be latent if they're so different? So that's where we are. That's the moment of our meeting here in this seminar, this third moment, this moment of darkening. So what should our attitude be to this? So are we just the victims of this historical accident? So our existence now, our intellectual life is cast at this moment. So it's like periodically a comet visits the Earth, Halley's Comet, say. A presage of great ruin, disaster, conflict in the world, like the Second World War, the Depression of the 1930s. And then everything is thrown up for grabs, and there's an institutional and ideological refoundation. And then it recedes into the past, it becomes ambiguous, and we begin to develop these ironic and tactical attitudes to it, and not to believe in the things that we ourselves write about it. And what can we do? Well, Kusuri said, just tough luck, bad luck for us, that our lives didn't fall at the moment at which the comet came into the Earth. We live in these normalized, post-normalization, darkening. So we might say to ourselves, let's get out of this business. Let's not depend on this comet. Let's be able to take this question of transformation into our own hands and not depend on the visitations of trauma to our historical experience to throw things open. Well, it's a tall order. So this, I haven't gotten it. So the next step would be the discussion of what renders this rationalizing legal analysis problematic. But I'd like you to think of this, I especially would like you to focus on this last thing I said, which is these three moments and their implications for the individual. St. Augustine says that all ages, all times are equidistant from eternity. So in relation to God, it shouldn't matter what moment of history we live in. But for these secular projects of emancipation, it seems that it does matter. And what happens then if our lives happen to have fallen into the wrong moment? Is this just our fate, objectively? Or do we have some power to revise our fate? That's the real underlying subject of the discussion. And we have to find indirect ways to approach it. Before we break today, would anyone like to make a comment about this final suggestion? I think it's a very common experience is to talk about these things as if we were talking about something distant from us, right? Like, oh, this is what they thought in the 19th century, or that's what those legal theorists think. But this is not about them, this is about us. This question now that I'm raising. Because are we just on this escalator? We just have to go along with this story? Or we can get out of this and redirect it in some way. The question is about the horizon of transformation of action. That's the real question. I don't think I'm going to get you to say anything else right now, but I would like you to think about this. Continue next week. Yes,
I still need to make a meeting to come and talk to you about my potential paper.
yes.
I figured